Okay, Coronado Gardens versus Ruby Soto, 25-08-123. Appearance, please.
Good morning, Your Honor. Marlene is Joan for the plaintiff.
And good morning, Your Honor. Sierra Oliver, P87707 for the defendant.
Okay, and I do see Ms. Soto is also present via Zoom. Today was the date that was scheduled for hearing for termination of tenancy. Counsel, I'm assuming you all have resolved this.
Yes, we did, Your Honor. We had submitted a conditional dismissal with an addendum last night. About 5 minutes ago, I did get a notification it was rejected for filing just because on the CD form we had said see attached and not see addendum. That was the reason for the rejection. So I can send that filing to the court email, or we can fix that word and change it to addendum and submit the CD afterwards.
Okay, can you put the terms on the record, please?
Yes. All right, let me get that up really quick. Okay, so the parties have entered into a consent order for conditional dismissal. The defendant is awarded conditional occupancy of the premises for a total period of 12 months from the date of this consent order for conditional dismissal, during which the defendant must not violate any terms stated in paragraph 2. During this 12-month period, if defendant is alleged to have engaged in any conduct prohibited or referenced herein, the plaintiff shall proceed with paragraph 4B as indicated on the first/front page of the consent order for conditional dismissal. The party specifically waived notice under MCR 2.602 C2D and MCR 4.201 M3 that upon material non-compliance with any of the terms stated herein, the action will be reinstated upon plaintiff's submission of an affidavit of default order of reinstatement of the case for entry of judgment in an order of eviction, which shall enter simultaneously without further notice or process to the defendant. Specifically, the defendant shall refer to Ruby Soto and all other occupants. Specifically, defendant agrees as follows. The defendant will ensure that she nor any occupants or guests of her household shall participate in any criminal activity or any act that deprives other co-members from enjoying the peaceful possession of their home, including public areas and any other privilege or amenity available on plaintiff's premises. Additionally, defendant agrees not to commit any act that interferes with the health and safety of others or right to peaceful enjoyment of other residents. Further, the defendant will ensure that neither she nor any other occupant or guest of her household participates in any act that interferes with the health, safety of others or disturbs the right to peaceful enjoyment of the property in any other co-member, including public areas or any other privilege or amenity available for the use and enjoyment of plaintiff's premises. The defendant must prohibit, deny, and must not encourage the individual Giovanni Davis from having any presence at or around any dwelling unit in which she resides. Mr. Davis has been permanently banned from the property, is not a lawful occupant, and under no circumstances will Mr. Davis be allowed on Coronado Gardens Housing Cooperative premises. Defendant shall fully cooperate in enforcing Mr. Davis's prohibition from entering upon the plaintiff's premises by immediately reporting his presence to the local police department and to management staff if she should see him or hear of his presence at the premises, and should not interfere with his removal. The defendant must make reasonable efforts to contact Mr. Davis and inform him of this agreement and the prohibition from the premises. Finally, the defendant shall pay all past due monthly carrying charges, if applicable, directly to plaintiff within 7 days after this consent order for conditional dismissal is signed. The defendant will not be charged any penalties for the past due amounts returned to her by plaintiff due to the pending matter. The plaintiff may accept these payments without violation of the park forest rule.
Counsel, for the plaintiff, that's complete and accurate, correct?
It is, Your Honor. Yes. Thank you. And thank you, Attorney Oliver.
That'll be the longest conditional dismissal I've ever heard. And so, Ms. Soto, I'm hoping you grasped all of that and you fully understand. Is that correct?
Yes, Your Honor, I do.
Okay, you understand that you had the right in this matter to proceed to a trial, and you could have demanded a jury trial.
Yes, Your Honor, I do.
Do you want to give up or waive that right today?
Yes.
Anyone coercing you to waive that right?
No.
Okay, I understand that partial performance of this agreement will not keep this matter dismissed. So if you violate any of those conditions, and there were a lot, they can have you evicted. You understand that?
Yes, Your Honor, I do.
A judge will enter on your record and there will not be another court date. You understand that?
Yes, I do.
Okay, you have 3 business days from today's date. If once you leave here, you realize that you actually in fact misunderstood the right that you've given up, you can return to the court and request to have this set aside, okay?
Yes.
Okay, counsel, it's already been signed. You're just going to either upload it or email it to my staff, you're saying?
Yeah, I can resubmit it via my file here in the next few minutes. We just have to change one word on the conditional dismissal for it to be accepted.
Okay, sounds good. Ms. Soto, do you have any questions for the court?
No, Your Honor, I do not.
Okay, any additional matters for the record, counsel?
No, Your Honor. Thank you.
Nothing further. Thank you so much.
Thank you, you're all set.
Thank you.
Have we seen Zachary Layton in Camelot Apartments? Zachary Layton here or no?
I don't know, Judge. My manager's here on that one. I do have 2 other ones ready.
Yeah, I don't understand why I'm dealing with the 8:30 at 9:30 though. And I have a trial that I have a jury that's here. I told him I'm going back on the record at
I had
9:30.
4 8:30s. Sorry.
Well, I only had one here and I'm the only one in the middle of a jury trial. And I think you were advised of that.
My apologies.
Is Zachary not here? I need to.
I will call the hall,
I
Judge.
think Mr. Campbell was here. No,
Mr. Campbell's here.
You
We've signed a
can
consent
call,
judgment.
you can call the hall. This is Cedar Place Apartment versus Michael Campbell, 26-00263. Appearance, please.
Morning, Your Honor. Ron Box here for the plaintiff.
Are you Michael Campbell?
Yes,
You can come forward, sir. Okay, today was the date that was scheduled for hearing for non-payment of rent. I have a consent judgment. States that you're entering consent judgment for the amount $978.09 plus cost $176.54 for a total $1,154.63. Is that correct?
Yeah,
Okay, that you'll pay that or you'll vacate by the 31st of this month. Is that correct?
yeah,
You understand that you have the right to have an attorney represent you.
yeah,
You understand that you have the right to proceed to trial. You could have demanded jury trial.
yeah,
And do you wish to waive both of those rights?
yeah.
Anyone threatening you to do that?
No,
Any promises to get you to enter this consent judgment?
yeah.
What promise?
What
promise was it?
No, no
She
promise.
said, yeah, I said any
Oh.
promises to get you, okay. You have 3 business days to return to the court, request to have that set aside. If you later realize you misunderstood the rights that you waived. You pass that to him so he can get a copy of that as well. We'll get you a copy of your paperwork in just a moment. Any additional matters for the record, counsel?
All
No,
right,
Your Honor.
Thank you. You're all set, Mr. Campbell. You can get
All
a
right.
copy of your paperwork.
just wait in the hallway.
That's fine, yes.
Okay.
I just signed a default for Mr. Riley, was it?
Yeah, oh, here, Zachary Layton.
You said who?
Zachary Layton.
Zachary Layton is here.
Yeah.
Yes, he's here.
Is Karif Bowers here? No Karif Bowers? I should counsel for that. Okay. Give him a couple more minutes. What about the matter with Lum and O'Berry? Are they here? The attorney, Lum is on Zoom.
Your Honor, I'm on Zoom.
Oh,
We submitted
Did you all
a,
resolve this?
we submitted a stipulated order to adjourn. I just want to confirm that it wasn't taken off the docket, so I wanted to appear.
Oh, okay. Sounds good. Let's see if we got it. Hold on. one second. I do see order to adjourn. I'll sign it today.
Okay. Thank you, Your Honor.
Thank you. Do you know how much time you need? You might be going. I think they were requesting 4-1, which has been blocked, they said, so we'll give them another bit. Judge? Yes. Of course. That's
Good morning. Good. The other two is out there. What's your name? What's your name? Yeah. Huh?
We got trial on 16. You're not gonna be here, but I know I can come back. You can be seated. Just inventory. Monday, that's right, I forgot about that. You can be seated. We got like all our favorite, like all our special cases. Literally, like, this is like the worst day of the second day trial.
I've had a bunch that went in one day, but I'm
Yeah,
here I am, day two.
yeah, I usually go into day two.
Okay, let's see what we got here. The hours is a default. Judgment. Not to bring the jury up in here. Okay, Bowers was the one who left before the consent judgment could be put on the record last week, that's why, okay. Do we know where the defense attorneys are? That's a pretty great. Thank you. Is opposing counsel here on a state of Lonnie Goss yet?
Yes, Your Honor.
Did you all resolve this?
We have not.
And you're intending to hold a hearing?
I spoke
If they
to
can, if she can come in here.
based upon my conversation with the top center, for with their.
Is that opposing counsel there?
Yes,
Okay, you want to move forward with the hearing?
based upon my conversation with Ms. Hofstadter, yes.
Okay, so we're in the middle of a jury trial that carried over from yesterday. So you got a couple options. You would have to wait until I think they have one more witness, and then I have to give jury instructions, and we can do it today, or I can give you a new date.
How long will that take?
How long will it take for them to finish? I would think they need at least another hour and a half to finish, to get the jury to deliberate, and then I can do the hearing.
We'll have to do a new date, because I have 2 back-to-back hearings starting at 1 today.
Okay, so March 25th at 8:30. March 25th at 8:30. Is that what's proposed?
It works for me, Your Honor, yes. Yeah.
Okay, thank you. Sorry for the inconvenience.
Thank you.
Thank you. The prosecution here, I don't think anybody else is ready to go on the record, landlord tenant, because they're not in here. Back on the record in the matter of the state of Michigan versus Garrett McCullough, 26-00025. Appearance for the record.
Ross Martina here for the people.
Jury in favor on behalf of the defense.
And I believe all the jurors have returned and are ready to proceed. Any matters to address before we call the jury back in and proceed with defense witnesses?
Nothing for the people, Your Honor.
Nothing from defense.
Okay, we can bring the jury in. Oh, the injury money is the one that
All right.
addressed in court. Oh. You can be seated. Thank you for returning promptly today. And hopefully we can get you all out of here before lunch today. I think there's just one more witness from the defense.
Yes, Your Honor.
Please can call your witness.
Defense calls Garrett McCullough.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. Counsel, I'm gonna let you voir-dire your client about waiving his rights.
Mr. McCullough, you and I have discussed your right, your absolute right to not testify, to remain silent under the Fifth Amendment. Is that correct?
Yes.
And you're voluntarily waiving that right and agreeing to be examined by me and also subject to cross-examined by the prosecutor.
Yes.
Anything further, John? Could you state and spell your first and last names, please?
Yeah, it's Garrett McCullough, GarrettMccalla.
And how old are you?
I'm 27.
You know Nicole Polka?
Yes, I do.
What is your relationship with Nicole Polka?
We're currently married.
How long have you been married?
This September, it'll be 2 years.
And did you marry when you were in the Air Force or after your service?
Objection to relevance.
It's still relevant.
It was,
Think that he's.
I have to address the objection. I'm sorry.
Please don't think he's.
I'm asking him, did you want to respond to the objection?
I'll withdraw it. I'm just asking a little bit of background information so that the jury can get a little information about my client. I'll withdraw them. I don't understand what the
Objection's
objection.
overruled. You can continue.
Before or after your service?
it was shortly after I got out, we met.
Okay. And did you live together at the R.G. Curtis address?
Yes, we did.
And do you have any children in common?
Yeah, just one son.
What's his name?
Michael.
And how old is he?
He's a little over 1.5 years.
Let's talk about the weekend of January 4th.
Okay.
All right. Saturday would have been the 3rd, Sunday would be the 4th, Monday would be the 5th. There's been testimony. You've been present throughout the trial. There's been testimony about those 3 days. Did you have contact with Nicole, with your wife, on January 3rd?
Yes, I picked her up from the airport,
All right, from which airport?
the DTW.
And where was she?
She was in Connecticut visiting her parents for the holidays,
And how long was she there?
about 2 weeks.
What was the state of your marriage leading up to that weekend?
Intact, but rocky.
Okay. Did you have any arguments with her on January 3rd?
She was argumentative. I chose not to engage for the most part of the 3rd.
Okay. So let's lead into the 4th. You're both at home together all weekend?
Yeah.
Right. You and Nicole and your son?
Mhm.
So yes.
Yes, sorry.
And let's talk about the Sunday, the 4th. Okay, how did that day begin in terms of your relationship with Nicole?
I had woken up with our son that morning, and I was up with him until about, I'd say noon. I put him down for a nap, and that's about when she got up, but she was sleeping in that morning. And that's about when it started. It was pretty much as soon as she got up, we started arguing about, she basically told me that she went behind me and put a restraining order on my best friend.
Okay, what's your best friend's name?
His name's Brian Chartier.
Was he there at all that day?
No,
But this was the subject of the argument?
it was.
And this is your best friend?
Mhm.
Yes.
Yes. Sorry.
And how long did this argument between the two of you over your friend last?
I'd probably say an hour, hour and a half.
Or just constant or off and on?
It was constant.
And on a scale of 1 to 10, 10 being the most heated verbal argument that you can imagine, where would you put this argument on this date with your wife?
8 or 9.
Okay, and I believe her testimony yesterday was 9 out of 10.
I believe so.
So you're both kind of perceiving this as a very heated argument at this point.
That's correct.
Goes through with the jury how the argument escalated and what happened next.
So after she did that, and she said that she was basically giving me an ultimatum saying like, it's either me or my best friend. I thought it was baseless, so I was pretty upset. And she started turning her threats towards me and towards Brennan, saying stuff like, I'll send somebody where he lives sort of deal. And so I was going to get a hold of him and just give him a heads up. She was like, good luck contacting him. I don't know what she meant by that, but I could not get a hold of him. So to this day, he still can't call my phone number or anything like that.
So when you say get a hold of, you mean blocked on your phone in some way?
Yeah, my mobile carrier's got no clue what's going on either, so I don't know what she did. But so that's kind of when I was like, I need to pack my things, get out of here.
Why did you decide to do that?
I didn't want to just stay there and be threatened, and I kind of felt like maybe my friend could be caught in the crossfires for rage, I suppose.
All right, so you were getting ready to leave. Where were you going to go?
I was going to go to his house first, and I was probably just going to stay there for the night, just give us some space. But yeah, I was going to go there and give him a heads up that she's saying all of this stuff. And
This was a Sunday.
yes,
Were you employed at that time? Are you employed?
yes,
And were you going to be working Monday morning?
yes,
And do you have a work truck?
yes, I do.
And is that work truck assigned to you, or do you have to go somewhere to?
It's assigned to me. I drive it to and from my house every day. I clock in and out from the driveway.
And is that the vehicle because of work the next day, and you were going to stay at Brendan's? Is that the vehicle that you're going to take?
Yep.
Is that a yes?
Yes.
Okay. Where are the keys typically kept for your vehicles?
All the keys are kept by the front door. It's like as soon as you walk in the front door, there's a key hook to the left. So all the keys there.
Right. And did you gather belongings, or what did you do before going to look and see if the keys were there?
So I went into the laundry room to start packing a bag full of clothes. And whenever I got out, she said, "You're not going to get very far without your keys." And that's when I looked at the key hook and I saw that there was no keys on it. So
How
I'm
many,
like,
how many
"Where are the
sets of
keys?"
how many sets of keys are typically on the key hook? So she says you're not going to get very far without your keys.
That's
Yes.
correct.
And what do you do next?
I asked her where the keys are at, and she says she doesn't know. So she has a diaper bag that she was hanging on like the dining room chair. And it was a lucky first guess. I just looked in the diaper bag. I found all 4 sets of keys. And, while I noticed the keys were missing, I also noticed that the debit card was gone out of my wallet. I asked her where that was too. She also said she didn't know. And then while I was looking through the diaper bag, found all the keys, didn't find the debit card. And I just decided to cut my losses with that and just continue packing the stuff and leave. But after I got the keys, that's when she had grabbed my work light, my work flashlight. And I was like, giving my flashlight back. And she didn't really respond. She was just kind of smirking. And
Let me pause you there.
okay.
The diaper bag.
Mhm.
She testified yesterday that she has a purse.
Mhm.
Does your wife typically use a purse?
No,
What would she use in lieu of a purse?
the diaper bag. She almost never carries a purse.
So you found your keys in this diaper bag.
Mhm.
Yes.
Yes.
Did you place them there?
No, I did not.
But that's where you found them.
Yes.
And I interrupted you when you were talking about this light. So Defense Exhibit A, I believe it was admitted yesterday, but is this the flashlight that you're talking about?
Yes, it is.
Is that an accurate picture of the flashlight?
Yes, it is.
If it has not been previously admitted, I would
It
move
was
the.
stipulated and admitted. So you can publish it.
Thank you. That's, so that's not your typical flashlight,
Correct.
kind of a vintage, is that like a 6-volt?
Yeah, it's a 6-volt lantern battery.
And it's got a handle?
Mhm.
So yes,
Yes, sir.
and so you're getting ready to leave. What happens in relation to this light?
She's holding the light. I tell her to give it back. She doesn't respond.
Why did you want the light?
Sentimental value, kind of like what the cop was saying. And I use it for work. I just bring it into the house. That way it doesn't kill the batteries being in the cold truck all night. So I bring it in and out. It kind of just goes with it.
All right. And she would have known that?
Yeah.
That's a constant item that you carry.
Grab it every morning.
And where is this taking place inside the house?
This would be in the dining room.
So at this point, do you have your keys?
Yes.
So at this point, do you have your debit card?
No.
To this date, have you regained possession of your debit card?
No.
What happens next with regard to the light? Well, let me ask you this. What else would you have needed before you had decided to leave? What else would you have needed of your belongings before you would have left?
At the time, I was determined to leave with the light. And I would have loved to have the debit card too, but I decided to cut my losses with that.
So what happens in relation to the light?
I reach for the light and I grab it from her and I take it from her.
As you're reaching for it, what is her demeanor?
Well, she's trying to pull it behind her, but she didn't get very far because I put my hand on it and then I yanked it from her hand.
Okay, did you demand your property back from her?
Yes,
Did she respond?
it was, well, when I demanded the keys and the debit card back, she responded with, "I don't know what you're talking about." And with the light, she didn't respond at all.
Verbally,
Verbally.
but she did attempt to take it out of your reach.
That's right.
And are you guys face to face at this point?
Yes,
And is it a 9 out of 10 argument still at this point?
yes,
Are you angry?
yes,
Does she appear to be angry based on your knowledge of her?
yes.
Where do you grab the light?
I grab it by the handle.
Where is she holding it?
The handle.
And as you can see in Defense Exhibit A, there's room for basically one hand. Is that fair to say?
Yeah, I'd say that's fair.
Did you intend to touch her hand?
No.
What was your intent when you grabbed at the light?
I was only intending to get my property back. I never intended to hurt her.
Right. How forcefully did you have to, was there a struggle over the light after you both had your hands on it?
She didn't let go of it on her own volition. No, I did take it from her grasp, probably 5 out of 10.
Like a twisting yank?
Say it could have been, but it was just, pulling it back, trying to get it out of her hands and into mine.
And were you successful?
Yes,
Did you, when you grabbed the light, did you intend to injure her in any way?
no,
You're face to face, you're at arm's reach, you're both holding the same object. And you are angry.
yeah, we both were.
Were you close enough to strike her if you wanted
Yes,
in any manner of ways?
yes,
Did you touch her in any way other than any incidental contact grabbing the handle of that light?
no,
You heard her testimony yesterday about you pulling her hair.
yeah,
Did you ever pull her hair?
no,
You heard her testimony yesterday about a bear hug, for lack of a better term, coming up behind her and squeezing her torso. Did that ever happen?
no, it did not.
Any other physical contact between you and she other than what you just described to the jury in the struggle over your property that she was holding?
No, the only physical contact would have been the light.
What happens after you get the light back into your possession?
She calls the police, and I just still kind of packing my things, grabbing odds and ends, and I think she has the phone on speaker or something, but she's talking to the police officers. And then I just said, tell the police I'll be waiting for them outside because I'm not staying in this house. I went out to the work truck and started it because it was freezing outside, and I just sat and waited for the police to show up.
You know how long it took for the police to come?
10-15.
When the police arrived, were you cooperative with them?
Yes,
Did you tell them the truth about what had occurred?
yes.
Did you have any idea what, could you hear Nicole's statement to the other officer inside the house?
No, I was in the back of the police cruiser. She was inside the house with the other officer.
Did you ever see her again after you had gone outside and made contact with the police that day?
No.
What were the condition of her fingernails when you picked her up from the airport Saturday the 3rd, Sunday the 4th, and then during this argument and the struggle over the flashlight?
Well, she's the type of person that if one nail comes off, she's ripping all of them off. So it's either all 10 or nothing typically. She had a full set on.
What about Sunday?
She wouldn't take them off that morning. She had just gotten up. So
During the struggle over your flashlight, did she have all 10 fake fingernails?
yes, she did.
Similar to the one pinky one that was visible in the prosecution exhibits?
Yes. It'd have been about similar length. Yeah.
And did you see her fingernails in court yesterday?
Yes, I did.
Is that comparable to the fingernails that she had on back in January?
No, it wasn't. That was the first thing I noticed about the pictures.
Oh, poorly worded question.
Sorry.
When she was in court yesterday, did you have occasion to see her fingernails?
Yeah.
She displayed them to the jury. They look, I don't know, I assume that they're fake.
Mhm.
Did that look like the type of fingernails that she had back in January?
Yeah, she does like an acrylic press on.
Did you ever go back into the house after your interview with the police?
Yeah.
And you were arrested?
Yes.
And how long did you spend in jail?
The night. Spent the night in jail and saw the magistrate. Well, yeah. And then I was released about, I would say 3 o'clock the next day, Monday.
So 3 p.m. Monday,
Yeah, 3-4.
January 5th.
Yes.
Going back to this debit card, what bank is this card?
It's Navy Federal Credit Union.
And is it in your name or both of your names?
The checking and savings is only in my name.
This debit card, what does that access?
The debit card is for the checking and savings.
What do you, and does she access that account?
Nope, I only use it for direct deposit and for auto pay for all of my bills.
Did she have her own debit card?
She does own a debit card with a separate banking that she had before we met, but it's not tied to me anyway. I believe that's a USAA debit card.
All right, so this particular Navy Federal account,
Mhm.
you have a debit card, it's in your name.
Correct.
Does she have a debit card to that?
No, she doesn't.
Did you make any transactions on January 5th, the next day, Monday?
No.
Did you come to find out that there were transactions?
Yes, I did.
How many transactions?
Objection calls for consent.
You said it calls for hearsay?
Many transactions.
You'd be getting this from banking records from personal knowledge.
From his own bank, objections overruled. You can answer the question.
2 separate transactions from the savings account, both at about $800, one 800 and then the other one 805.
So over $1,600
from Simmons.
withdrawn while you were in jail Monday, January 5th.
Yes,
Did you authorize those transactions?
absolutely not.
Did you come to discover that a divorce petition had been filed against you?
Yes, so on January 6th, first thing in the morning, I went to friend of the court to file for a divorce. And it went through and everything. I thought had beaten her to it, but we had gotten online and saw that public record had stated that she filed for divorce while I was on the fit.
So the day after this incident, you discovered that she had filed for divorce.
Yeah, she beat me to it by a day.
When you were released from custody, was Nicole still at your marital home
Yes,
on January 5th?
yes,
Nicole was still at home?
yes.
Where, was there no contact order put in place by the court?
There was no conflict order in place.
Did there come a time when you learned that she had left the home?
Yes,
Tell the jury about that.
I have an ABT security system. So after I got released and I got my phone back, I went to stay at my mother's house and I was looking at the ABT. I knew that her parents were there and that she was there and they were basically just moving all of this stuff out of the house. They had purchased storage since on my one of my cards, I believe my credit card. And they moved a bunch of the stuff into storage, packed up the U-Haul, and then they left. And
What day was this?
I believe they left.
January 6th.
Yes.
Michael with her?
Yes.
You're currently in a divorce proceeding?
Yes.
As we sit here today.
That's correct.
Are there court proceedings specifically on the issue of custody?
What do you mean by court proceedings?
In the divorce, is the subject of custody of Michael going to be a litigated issue?
Yes.
Neither you nor Nicole is going to voluntarily relinquish custody of your child. It's going to be up to the court to decide.
Yeah, I would assume that's the truth. I don't think she's going to.
And what about you?
Absolutely not.
Thumb injury. If anything to her left thumb occurred during this incident, as she is alleging, could that have come from any other contact between you and her other than the grasp and the struggle over the flashlight?
No.
If you had any other physical contact with Nicole during this incident, this 9 out of 10 heated argument, did you have any other physical contact with her that day?
No, I did not.
Did you intend to injure or batter your wife at any point during this incident?
No.
No further questions.
Cross-examination.
So I apologize if you have to jump around a little bit. A few things to go over. Notes in different places. So you've been watching this whole trial, right?
Yes.
You've been paying attention.
Yes.
Been taking pretty diligent notes.
Yes.
You were here yesterday when Nicole testified, right?
Sorry.
You're paying attention to her testimony,
Yes.
taking diligent notes on her testimony.
Yes.
And have you To your knowledge, the police report in this matter, was that conveyed through attorney?
Conveyed the police report?
Yes.
Yes,
Have you reviewed the police report?
I have.
You reviewed your statement in the police report?
I have.
You reviewed Nicole's statement in the police report?
I have not.
But you did review your own statement, right?
Yes.
You heard Nicole's testimony, right? She did not review the police statement.
Yes.
And then fair to say that a night passed between Nicole testifying and you testifying, right?
Yes.
So you had a good, I don't like doing that. So you had a long time, you got to sleep on it and think about how you could respond to her testimony. Is that fair to say?
Yes.
You've discussed your testimony with your attorney, right?
Yes.
So is it fair to say that a lot of planning and thought has gone into your testimony?
Yes.
Is it fair to say that you had a very good opportunity to make sure that your testimony today lined up with what you told the police?
Yes.
Fair to say you had an excellent opportunity to make sure that you could thoroughly respond to Nicole's testimony, right?
Yes.
And you were aware yesterday that Nicole was going back to Connecticut today, right?
I wasn't aware until, sorry, what was the question?
Were you aware at the end of court yesterday that Nicole could not be back today?
Yes.
So you testified aware of the fact that she would not be able to respond to anything you said, right?
Yes, I was hoping we could testify yesterday.
And is it true yesterday that she was not asked about getting out a protective order against your friend, right?
Can you repeat that?
Is it true that no one asked her yesterday if she took out a protective order against your friend?
Yes, that's true.
So then she does not have an opportunity today to respond. to your
Objection, Your Honor.
Council approach.
We'd like to carry the structure on that point too.
Absolutely. I'm just gonna strike the last set of questions to the, and answers to the witness about his knowledge of the alleged victim not being here today. He was expecting to testify yesterday. We thought we would finish this yesterday. And at the end of yesterday's date, the prosecution made a request for that witness to be excused and not have to return. So that's stricken. You can continue.
Okay, moving on from that. Now let's talk about the statement that you gave to the police. You did talk to the police on January 4th, right?
Yes.
And you were in your truck when you spoke to the police?
The third?
Or
No, sorry,
you
it
were-
wasn't. Sorry.
Of course, sorry. You were in your truck when the police arrived,
Yes.
and you indicated that you had been in your truck for 10 or 15 minutes, right?
Yes.
So you had 10 or 15 minutes to think about what you were gonna tell the police, right?
Yes. That's not what I was doing. Suppose
Okay, that's not what you were doing, but you did have that opportunity.
Yes, I had the opportunity.
But you're testifying that you did not think about what you were going to say. to the police.
No, I was calling my family to tell them I was going to jail and nobody picked up. So
Okay,
I called like 4 people and then my brother finally picked up.
understood. Now, let's talk about People's A. This is the flashlight in question, right?
Yes.
And you use this flashlight at work.
Yes.
You indicated this has sentimental value to you,
Yes.
and you would not want it to be damaged, right?
No, I wouldn't.
So even though it's sentimental and you would want it to be protected, you use this at work.
Yes. It's very sturdy. It's all steel construction.
Okay. Now, when the two of you were arguing, what was your, I guess, demeanor, disposition like when you were arguing?
What do you mean?
Were you angry? Were you calm?
Yeah, we were both pretty angry.
Nicole testified that she was yelling. Were you also yelling?
Yes.
Were you also your family?
No, yes.
Now, is it fair to say that when you were in the truck, you had a chance to cook up an innocent explanation for how Nicole?
Objection.
Is that right?
Action argumentative.
It's cross-examination.
Argumentative is not cross-examination. Leading questions are. Isn't it?
Your question is isn't it fair to say that while he was in the truck, he had a chance to cook up?
An explanation for how Nicole hurt the thumb.
I think he doesn't like the way it was formatted. I think it could have been formatted differently, but I'm gonna allow the question, the objection.
I can phrase it.
It's
more-
fine. He can answer the question.
Yes, I would argue she had the same opportunity.
But isn't it correct that she called the police before you went out to the truck?
Yes,
So she did not have the 10-15 minute window before speaking to emergency personnel.
no, she didn't. Apparently.
Now, getting into Exhibit A, I guess, love the Polaroid, by the way, very fun. Could you sort of show me with your hands how wide that opening is? 'Cause it's hard to tell scale.
Probably not like this.
Okay, about that wide. And
Yeah.
where was Nicole's hand? Was her hand up on this handle here?
Yes, it was.
Was it sort of centered in the handle?
No, she had it kind of choked up towards the bulb there. So
Okay.
where I grabbed it was towards the back of the hand.
Okay. Now you indicated on direct, there was not room for two hands on the handle of that flashlight, right?
Yes, that's right.
So then you knew when you grabbed it that it was not possible to grab the flashlight without grabbing the hand, right?
That's correct. It'd be like a hindsight 2020 thing. I was
And you intentionally grabbed the flashlight, right?
the light. Yeah.
So then is it fair to say that you intentionally grabbed it?
Yes, I suppose it was fair to say.
And how long was your hand on her hand?
The struggle over the light was probably 5 seconds.
So that was, were you squeezing down on the light while you were trying to get it away from her?
Well, I was, I just grabbed the light and I pulled it towards me and it came out of her grasp.
And it took about 5 seconds for that to happen.
Yeah,
And during that whole 5 seconds, your hand wasn't on her hand squeezing, right?
I can't say in full confidence that it was.
But you could say in full confidence, there's only room for one hand on that light.
One hand comfortably. Like I said, about this long, so. her
So
hand's
now you're
serious,
saying that
so-
there is room for two hands on there.
Not comfortably, no. It's meant to be handled by one hand, but
So when you were pulling it, was your hand over her hand or were they side to side?
it'd be sights.
Okay, so it sounds like a second ago you testified that your hand was on her hand, now you're saying it's side to side.
Well, a second ago, I said that I could have possibly touched her hand for sure, but it wasn't my intention to go for her hand. My intention was to grab the property back. I wasn't trying to hurt her hand.
So it's your testimony today that you did not touch her hand.
Objection, that's not what the testimony was.
I don't think he said he didn't touch your hand. I think he said it wasn't his
The answer is
intention.
no. But it's possible you did touch her hand?
It is possible.
Okay. So it's possible you were squeezing her hand while you were pulling on that flashlight.
I don't see how I would. So if you look at the picture here, the actual gap between here and here isn't very large. So for me to wrap my hand all the way around her hand, I mean, it doesn't make sense. And I wouldn't have a good grip on the light. And if I'm holding her hand, then how did I get the light from her? You know what I mean? I'd just be yanking her around. So I grabbed it from the back.
So like the back of the handle is where you grabbed it?
Yeah.
Now, you heard her testimony that she said you're hurting my thumb, and then you said, I don't care.
I did hear that.
And did she say you're hurting me, and did you say I don't care?
No, that's not how.
And so you did not say it. She said,
I did say I don't care, but that is not what she said.
okay.
After the flashlight, while she was on the phone with the police, she said, I think you broke my nail. That's when I said, I don't care.
Okay. Do you recall saying, quote, she said that I hurt her thumb. At the time, I didn't care.
No,
You don't recall saying that?
is this the police statement?
No, it is not. This is a phone call.
No, I do not.
If you were to hear your voice saying that, would it refresh your memory?
Yes,
No, it's not an exhibit.
It's not an exhibit, it's refreshing.
But it's gotta be done outside the presence of the jury.
That's right, it's close quarters.
This was, what are you gonna play? Body cam?
It's a jail call.
And may we approach.
Okay. A council appearance, please. Stand back behind their stuff because I'm in the middle of a trial. I'm not gonna make them move their things.
So,
Your name?
Edward Christensen, Derek Lewis.
Okay, and you all were supposed to work on a resolve as it relates to the amount that's owed. My understanding is that you didn't come to an agreement, or is it about the terms of repayment that you didn't come to agreement?
Terms, sorry.
So you did come to agreement about the amount, obviously, or no, I ordered an amount.
Here's the thing, Your Honor, we were to exchange the PayPal invoices over the last year to make sure that
The accounting was
our
accurate,
ledger matches with their records.
correct?
That did for the last year. They had some discrepancies going back to 2021. I thought I recalled you saying we're not gonna go back 3 years.
It doesn't matter, if the ledgers needs to align, if they've made payments, I just wanted them properly accounted for it, and the witness, ma'am, can you give me your name again?
I testify.
She shared at the end of last week's hearing that there was a payment in December that was not reflected.
No, that was reflected on the ledger. Your Honor.
Okay, so you agree that that was reflected? Okay, so what is the judgment amount that you have?
Well, as you recall, you discounted $1,700 for the
A month,
1-day lockout, and then we discounted $600 for damages to some headlights or something along those lines. We agreed to lower the amount.
Okay,
So after those discounts, it came down to a total of $8,000 even.
okay, so the issue is about repayment.
It is, Your Honor.
What's the issue? How much do you want him to pay upon?
We wanted to do it over a year's time. They countered with 3 years.
Your client wants to do it over a year. How much would it, give me amount, that's a lot of math. How much per month is that?
It's $808 per month.
$800 a month? Let's see, $8,000. Yeah, and you want them to pay it over 12 months, it's about. $8,000 even. So it's about $667 a month. And you say you can't do that.
No, yeah, Your Honor, when we left, that was kind of the thing that I was kind of skeptical about, like, how do we agree upon the terms of how long I'm gonna get? Pre-trial, he came in and said, well, it doesn't matter if he can pay it off 5 years, I don't care, but we need to get something on paper and get him over the payments. So
I
it went from
agree.
5 years. to
I agree that needs to be a payment schedule.
Yeah, I agree as well. But it went from 5 years to a year. And I also stated like they could come in and say, I want $500,000 a month. You said that that would be suitable. You don't think that they would.
They're not, that's for $667.
That's $500.
Okay, and you can't, and yeah, you can't afford to make that payment?
Not on top of relocation and double building costs because I had to relocate because I have.
Okay, they've already discounted this substantially too, from what the judgment amount was going to be. You recognize that?
Correct.
You do recognize that?
I have no problem with the amount. It's just the term of over time.
It's
I don't
not about you having a problem with the amount. It's about you understanding that they're making some concession. Are you willing to make the concession?
Yes.
Okay, and so you want 3 years to pay it off. Okay, if we gave you 36 months to pay it off, that means you would be paying $222 a month to him. And that you think is fair and appropriate for holding over the property for as long as you held it over.
I mean, yes, because due to the discrepancies that we had, there was a lot of agreements that were verbal that he was wiping debt and that I have no proof of, so I just have to take it. That number isn't even a true number, but that is the only number that I can accept because of the verbal agreements.
I get all of that, but we also do know that you were occupying this property and that you actually, even before any issues were ever reported, were behind in rent. You essentially were behind in rent from the majority of the time you were there.
So prior to looking at the ledger,
yes,
that is what I set.
Uh-huh.
But looking at the ledger, it's been times that I have more money. I paid in more money. than
That you were paid in advance, you believe?
Correct.
Well, that wasn't what was brought in on the record. I think I can split the baby for you all. Well, that. Order of the court is he'll get 24 months to pay it. It's $333 a month. Okay? That's what you all were supposed to do. You're supposed to, if he said he want one, you said you wanted three, you meet in the middle.
We tried.
Well, there you go.
definitely
And we're
tried.
done.
I tried. And I just had one other thing.
And
before
hopefully you
signing.
can get it paid off, hopefully you come into some good fortune, you can pay it off in advance and then put this whole thing behind you.
But
You had
also,
something else?
yeah, I had one more thing. Also, last week, I kind of brought up that the lease was incomplete and that I'm being sued personally opposed to an LLC. And that he's suing me from his LLC and he's on the lease as a personal entity. I'm not trying to.
So here's the thing, if he had sued your LLC, you would not have to pay an attorney to come represent you. You do know that.
No, I can't.
You cannot represent an LLC in court. That's the law. That's why he has an attorney. You cannot represent an LLC. It has to be represented by an attorney. So what would it cost you? What do you want to do?
And we looked it over and.
At this point, you got a conditional dismissal. It's being dismissed with the condition that you make
And
this
I
payment.
appreciate
You're
it.
literally winning front and back at this point.
And I appreciate it. I do. I know that. I know.
So judgment is for a conditional dismissal in the amount of $8,000 to be paid over the next 24 months, okay? Randy sent me an email about the escrow. Oh, there was an escrow of already 4,000 and that's gonna be released to them anyway. So now you only owe 4,000.
No, with the, that's half, the 4,000.
Hold on. Well, then you can't,
No,
you told me you agreed on an amount of 8,000. You didn't agree on an amount of
No, no,
8,000 then.
The original amount was 14,300. We discounted.
You
the
can't
4,000.
discount based on what's in escrow. Escrow is held with the court. You gotta give me a judgment amount. You're not saying I'm applying that. Obviously, I'm gonna make a determination as to where the escrow is gonna go. You agreed on a judgment of 8,000 because I had one for 13,000 and some change. So what did you agree on? So you didn't discount.
Well, when I put it in the order, I said that the $4,000.
That's not a discount.
Oh, it's being released to the plaintiff.
That's not a discount. That's a payment towards the balance.
I agree. Well, I guess it's the wrong terminology.
Oh, it's absolutely the wrong term. Because you said it was 8,000. That's why I said they discounted it down to 8,000. No, this is being held in escrow. And your agreement is that the 4,000 is going to go towards the balance. So what is the balance of the conditional dismissal?
The balance would be 12,000.
$12,000 even is what you agreed on?
Yeah.
Okay, and they're gonna apply the 4,000 in escrow.
I guess my question for that is, I didn't have to put the $4,000 in escrow then, right?
Yeah, you did.
Oh, okay. All right. Okay, so I did it right there. Say, that was the attorney money right there.
Okay. That's a judgment of the court. Conditional dismissal, dismissing the case today upon the condition that you pay $12,000. The escrow of 4,000 will be released to the plaintiff to deduct from that 12,000, and then you'll make a payment of $333.33.
Is that what you deducting the 1 month for the lockout and the headlights and that?
That included the 1 month, and they took some more off because my amount was 13,000 and some change. They brought it down to 12,000, so they gave you a little bit more off too. Okay. Okay. You have any other questions at this time, sir?
No, sir.
Okay, I really think that you could pay this off sooner, but I know you don't want to be in a situation where you're squeezing blood from a turnip. So $333 per month for for 24 months, and then that'll resolve this matter. Any additional matters for the record?
I did.
You have a conditional dismissal?
I
I can edit it to say what I wanted to say.
Thank you.
Okay, also, you're gonna vacate the 31st, which we discussed last time. The remaining amount of 8,000 shall be paid in 24 months.
Still gonna pay the thing. Yeah.
Oh, we submitted the current month's rent too.
And you're making those
Which is
payments on the 15th of the month. Tenant shall continue to pay rent until the 31st. That's included in here. If you all can sign that, we'll be all set. Okay, you can step aside. I think I gotta call the next case. Thank
Okay,
you.
Thank you.
Thank you.
Are we also with Miss, are we ready with Miss Bombi? Did you come to a resolution on that one?
No.
I'm gonna have to reset it.
Yes, that's.
Can you give them a new date? March 25th at 10:45. Okay. Let's see here. So the issue with that one. Okay. Was the mold issue taken care of?
Yes, ma'am.
Okay. And then, so what's this lingering issue now? Has to,
Doesn't think she has any rent.
she doesn't believe she owes any rent. Is that because of the mold issue?
She says because of everything, yes.
Excuse me, can I, am I okay right here, Judge?
You're fine.
Okay, so it's not just the mold. It was also the ceiling.
Ceiling caving, it said there was living room and bathroom issues. I think she had a number of issues.
Excuse me.
Yes.
Like, they most recently, and I am appreciative, they most recently got a shower finally.
Got a shower?
The shower. The shower was the initial problem that caused the mold. It was not ADA compliant. They have had a quite a high turnover of Lansing housing. The problem started to occur during COVID. And as you know, like, it was a lot of people were out of work. They lost, a lot of staffing, maintenance. So I tried not to take it personal, but it was a lot of neglect, abuse. Judge, I'm now receiving full-time care because of just things that were not repaired, like that shower, it caused like more of a breakdown, with my health.
Okay, well, we'll have a hearing another time so that you can bring your evidence.
Say that again.
We'll have a hearing and you can bring all of your evidence, okay? And subpoena and call any witnesses that you want to call to support your claim. I just don't have the time to do it now because I'm in the trial, as you've been seeing. And then you'd be sitting there for a while waiting, and I don't want that either. Okay,
Excuse me, can
so
I make a request?
yes, you may.
Thank you. Unfortunately, just as of last night, my father's been in hospice for probably I'd say 4 months. But he's currently making a transition. It's a lot for me. I just got moved back into my home. In your courtroom is an example that barriers, no compliance, a lot of places.
Yeah.
And this is how my home was. I just want to give you an idea. Getting into the Airbnb, it's taken almost 3 years for them to help, and we find somewhere for me to go so that they could repair. And like I said, changes in their staff, and now I have this going on with my father making a transition. If I can get like 30 days to, I'm currently in seeing a psychiatrist, and working through things. But I'm just asking for some time while I have these things going on.
You mean before your next court date?
Yes, if I can at least
Okay.
get 30 days while these
I don't
things are
think we
going
have a
on.
date tonight. Yeah. We were gonna have to set it out at least 3 weeks anyways.
I'm actually gone March 25th through.
That was the next day we had anyway, so we'll go the week after. Until when?
I am gonna be out until I get back in the office on April 6th, so.
We'll set it after that. I'll keep you in your prayers during your situation with your dad. I just recently lost my mom, so I understand. It's a lot to handle. April 8th at 9. April 8th at 9, okay?
Sorry. you're not first. Thank
Judge,
you.
Judge, I know that you did sign that order. You're just gonna enter the new date. I don't know if it's entered. in the system, just
Did I
shred
sign it? Where is it? I had not even put a note in there in my file, so I don't think it's in there.
I didn't upload it.
Yeah, we didn't upload it, so it's not considered, yeah, that.
Yeah, so just shred that.
I think she walked in right after I handed it to him. Okay, we'll get you a notice to appear. Any other matters you have today, ma'am?
No.
Okay, thank you. Thank you. You had another one though, didn't you?
Yeah, we have CD.
Just under this one, sorry.
Oh,
That's the
Jared.
matter. That's the one you just did.
Oh, that's the one I just did.
Sorry.
SK Lansing Limited versus Brittany Hill. 6-00667 appearance.
Morning, just the appearing of that plaintiff.
Okay, and you are Brittany Hill, correct? Okay, Ms. Hill, I have a consent order for conditional dismissal. States that the case will be dismissed today upon the condition that you pay the past due rent, $1,555. That's rent due through a period of March 31st, 2026. That you will pay court costs $177.04. Total amount $1,732. Says total balance as follows. This is the repayment, $591 by the 6th of March, 2026, $868 by the 20th of March, 2026, and then $273.04 plus April's rent by April 3rd, correct? You understand that you have the right to be represented by an attorney during this eviction? You also have the right to have a trial, and you could have demanded a jury trial. You understand that? You wish to give up both of those rights? Anyone threatening you to do that? Okay, partial performance will not satisfy that agreement. To keep that dismissed, you have to do exactly what you said you were going to do, or pay it all off earlier than that. Otherwise, if you don't, the plaintiff can have a judgment entered against you. You will not get a new court date. You understand that? Do you have any questions for the court? We'll get your copy of the paperwork in just a moment. Thank you. Mr. Barkley, you have one?
I do. CD.
Oh, which one?
It is Silly Goose LLC and Copolis, Bazo Copolis.
Okay, that's file number 26-00380. Appearance, please.
Yes, good morning, Earl Bach here for plaintiff, Silly Goose LLC.
State your name, ma'am.
Morgan Battle.
Your name, ma'am,
Zena Copeland.
and your name, sir?
Ted Copolis.
Okay, today was the date scheduled for hearing. How are we proceeding on this?
Yes, Your Honor, we agreed to enter a consent order for conditional dismissal. Time to rent $4,148.53. That's due through the end of March. So $221 in cost for a total of $4,369.53. The defendants have stated that they can pay $2,000, pretty much now. I put $3,926. And then they're going to pay $1,500 each month by the 5th, starting 4/5/26. Payments shall be allocated towards the accruing rent first, and then the past due balance second, and payments to continue until the balance is zero and current.
That's complete and accurate as to how you want to address this?
Yes.
I need a yes from each of you. If that's how you want to, okay, you can provide it to me. You understand that you had the right to be represented by an attorney?
Yes.
You have to answer.
Oh, yeah.
Okay, you also understand that you had the right to have a jury trial in this matter?
Yes.
Yeah.
And are you each willing to waive those rights?
Yes.
Anyone coercing you to do that?
No.
You each sign this, correct?
Yes.
You understand that partial performance of this agreement will not keep this matter dismissed. So if you want to keep the dismissal, you got to do exactly what you say you're going to do here, making the payments in the amounts, like you said, okay? Otherwise, judgment can enter against each of you and you will not get a new court date for that. You understand that?
Yes.
Okay. You have 3 business days from today's date to return to the court. If you later realize you misunderstood any of the rights that you've given up, you can request to have this set aside, and then you'll explain how you misunderstood your rights, okay?
Okay.
We're gonna get you a copy of the paperwork and you're all set. Any additional matters for the record?
No, Your Honor, thank you.
Thank you.
Done here, so 2:00.
And that was my last hearing. Why is Leighton being adjourned?
He's got a stack of exhibits about this tall, and,
Okay,
and
I just wanted to
he's
know
talking
that, that's all.
They pretty much agree, and I think we're gonna be able to dismiss this. What is this?
Oh, it might be dismissed.
Yeah, fingers crossed.
Got it. I'll note that. I just wanted to know why it was adjourned.
I think there's a lot of moving parts. He works for the landlord cleaning and stuff, and he wants credit for some of the work he did.
Hopefully you all can work that out. I see him a lot in here lately. Yeah. But he might have another matter going on too. Okay, sounds good. So we can bring,
Okay, it's 5.3, witness who has been interviewed by a lawyer.
5.3.
Should my client take the stand now or after the jury
You can
comes in?
take the drip stand.
She said, okay.
We don't have to redo the oath, do we?
Yeah, you're still under oath.
Okay.
I'm ready. All right. Just, that's all you need to say. Okay, you can be seated. You can proceed, counsel.
Sorry, gotta recollect myself, get back into it. So let's circle back to the flashlights.
Okay.
When you went to your truck, where was the flashlight?
Could have been in my backpack.
Was your backpack in the truck with you?
It was.
Okay, so you put the flashlight in your backpack and then went out to the truck with the flashlight.
Yes.
So if the police didn't see your flashlight in the truck, it's because it was in the backpack.
Objection. The testimony yesterday was that there was no search for the flashlight by either officer. So it wouldn't matter where it was.
Well, I wasn't asking if they searched for it, like if they were looking and didn't see it.
That's fine. I think it's clear that
It's
that the
implied.
officers made, that they didn't do any search for it, but I'll allow the question. Objections over.
I think the question was if the police did not see it. It's because of it.
Yes.
Okay. Now. Looking now at people's exhibits 2 and 3. Now looking at exhibit 2 was, if you don't know, you don't know. After you got the flashlight from her, was there that damage on her finger? On her fingernail?
I don't believe so. I don't even think her nail was off yet.
And then the swelling on her thumb there, was her thumb, if you know, swollen at the time you left the house to go to your truck?
I would not know if it was.
Okay. And is it fair to say that you don't know what caused the swelling, what caused the fingernail damage?
I suppose.
And you do acknowledge that in these pictures, her thumb is swollen. That's not usually what it looks like.
Her thumb is somewhat deformed. It's hard to tell from the pictures whether or not that's just a weird angle of it or if that's de-swelling. She, it's like she testified yesterday. She had a bullet go through it once. There's like no bones right there. She doesn't
Okay,
have
well,
like-
let's just wait for another question.
Okay.
Now. So you testified that she still had the false nail on her thumbnail after you left to go to the truck?
Yeah, I believe she did.
Okay. So then, obviously in People's One, it looks like all except for the left pinky have had them removed. Is that right, in Exhibit 1?
Correct.
So if they were still on when you left and no one else was in the house, does it stand to reason that she must have removed them all herself while the police were on the way?
That would be my guess.
Okay.
It usually.
I guess
once-
you weren't in there, so you wouldn't necessarily.
Usually once she loses one, they're all.
Now, is your testimony correct that you were the one who was leaving, not Nicole?
Correct.
And isn't it true, though, that after you, day or two after you got out of jail, you ultimately did go back to the house?
Yes.
And you've been living there ever since, is that right?
No.
But in the immediate aftermath, you were living, right?
So I was kind of waiting for the court to decide. So she was, whenever you get arrested for the domestic.
Let me clarify the question. Once you were given permission to return to that house, you did return to that house.
Yes.
Okay. And is it your understanding that she left the state while you were still in jail?
Yes. No, she left the state after I was released.
Okay. But it was shortly after this happened that she left the state.
Yes.
So ultimately, she did leave and you did the next.
Yes.
Now, getting into the money that was withdrawn. When the two of you were married, who was the financial provider?
That would be me.
And was her responsibility more, I guess, being a stay-at-home parent?
That's the responsibility she chose.
Okay. So she would not have her own means to care for herself or her child without you, is that correct?
God without me, no. Other than her parents, I suppose, family.
Now, you indicated that you went to file for divorce and then found out that she had already filed for divorce, right?
That was my understanding.
Is it possible that she in fact had filed for custody, not for divorce?
It is entirely possible. I didn't think you could do one without the other. I figured you'd have to file for divorce in order to get custody.
But if you were told that she had filed for custody, not for divorce, you would have no reason to dispute that.
Can you repeat that one more time? Sorry.
So let me actually, that's that question. Let me an approach with a court record the defense counsel has already had an opportunity to review. If you look at the second page.
For refreshing recollection, he didn't say he didn't remember.
Okay, I apologize. Let me just take that.
He may not even dispute it.
Just to be clear, you are not disputing that it is possible she filed for custody, not for divorce.
No, I'm not disputing.
Okay. Thank you for clarifying that. Although she's filing for custody, it probably stands for the reason she wants to.
Yeah, that's what I assume.
That's that. all the questions. I have. Thank you.
Let me read her.
Briefly, Your Honor, thank you. Garrett, you did review your statement documented in the police report, correct?
Yes,
You hired an attorney.
yes,
You and I consulted about the trial pending, correct?
yes,
Is this a serious matter for you?
absolutely.
Prosecutor asked you if you had time to think about what you were going to say to the police. Were you honest on January 4th when you talked to the police?
Yes,
Is your testimony today in court consistent with what you told the police back on January 4th?
yes.
Did you anticipate testifying today, or what was your understanding of when you would be testifying as we led up to trial?
I was hoping we could wrap it up in one day.
So you're expecting to testify yesterday?
Yes,
If the officers, either officer, had asked you about this flashlight,
Mhm.
and it was in your backpack, would you have consented to showing them where that is, had they asked?
100%.
When you testified, when you spoke to the police and said that you were going to a friend's, and when you testified today that you were trying to leave to go to your friend's house, Brendan, were you intending to stay indefinitely or overnight?
Overnight.
And those were the belongings that you had packed up, was to just get out of the argument and leave overnight, not to move out.
Right. To avoid further escalation.
Nothing further.
Any questions of this witness from the jury? Counsel, you can approach. Okay, sounds good. Thank you.
Thank you.
Okay, let's see, Mr. McCullough, you mentioned something about a security system. Is this inside the home or outside the home?
It's outside the home. I have, well, it does all of the doors and all of the windows on the first floor. If any of them open or shatter or anything like that, it's supposed to tell me, but I have one camera by my front door. And that's what caught, the U-Haul and everything.
Okay, so this security system wouldn't have been something that could have caught the actual incident in question?
I wish, Your Honor.
Okay, very good. And the question that was posed to address the other portion of that question, this witness would not be able to testify as to why an officer said what they said, but I try to think that helps explain the security system situation. The other question is not relevant, so I'm not able to answer that. Any other questions? Good questions, though. I have some of my own non-relevant questions, but I've not asked them, because I would like to know more information about things that have nothing to do with domestic violence. So unfortunately, we're not able to answer those questions. But if you have anything that you think you may want to know about that's relevant to the elements of this case of domestic violence, you got to ask now. before he gets off the stand. Okay, sounds good. Thank you, Mr. McCollum.
Thank you, Your Honor.
Any other witnesses?
Defense rest.
Is the prosecution calling rebuttal witnesses?
No, Your Honor, no rebuttal.
I'm just making sure that I have all of the composites that you requested, because I don't think the defense requested it. Okay, in the interest of time, I typically would send it to you, but I just put everything you asked, and you added 5.3. That's it, correct?
That is correct, Your Honor.
So let's do those, and then we'll move to your closing arguments. So for the jury, you can place your attention to the screen for our composite and final set of instructions. Okay, members of the jury, the evidence and arguments, well, the evidence, we're going to get to arguments after this. In this case, are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions, but ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about January 4th, 2026 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions along with you and your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all of my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all of the instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty.
Yes.
Oh. I have prepared a verdict form listing the possible verdicts. Did the prosecutor and defense review that? You can show it. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking the same example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, and how he did it, or by any other facts and circumstances and evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness said in each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There is nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Again, the elements of the charge of domestic violence. The defendant is charged with domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted or assaulted and battered Nicole Polka. A battery is a forceful, violent, or offensive touching of a person or something closely connected to him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Nicole Polka's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Nicole Polka reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit the assault, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Nicole Polka was one of the following: either the defendant's spouse, the defendant's former spouse, had a child in common with the defendant, was a resident or former resident of the same household as the defendant, or was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent, intimate association, primarily categorized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The definition of force and violence, as used in these instructions, the words force and violence means any use of physical force against another person so as to harm or embarrass him or her. Definition of touching: for a battery to occur, the touching must have been intended by the defendant, that is, not accidental, and it must have been against Nicole Polka's will. It does not matter whether the touching caused an injury. Actual injury is not necessary. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. Closing argument.
I'd like to thank you all again at the end. I think just everyone, fun Tuesday, Wednesday. I think most of you probably would have preferred to not come back today. You all are here, you're doing your civic duty, and I applaud you for that. Thank you for that. Now, this case is about two simple things: power and control. It is about Garrett McCullough's exertion of power and control over his wife. That's what this is about. What else this case is about? It is about January 5th. It is not about money withdrawals on January 5th. It's not about divorce filings January 6th. It's not about a U-Haul. It's not about Brendan. It's about January 4th. And I said that at the start. With cases like this, it's family law. I practice criminal law. lot of you gotta have a certain type of person go into family law. 'Cause it's messy. And there's so much more than we can ever give to you. There's most of that background doesn't pertain to this. So I would ask you not to get too deep into speculating about the past and the future. Aside from what gives you context of January 4th. Now, I do want to just sort of walk through the theory supported by the evidence, the story supported by the evidence. What I submit to you, the evidence shows that these two, I don't think that anybody in this room is going to say they had a great, happy, healthy marriage. These two were fighting. They were fighting the whole weekend. You know, Ms. McCall testified that he was the bigger person, non-participant for a while. That to me, not some incredible testimony. They're arguing, they're fighting. It gets more and more heated. Nicole says, you know what, I'm leaving. Eric doesn't like that because that is pushing back against his authority over her. For her to say, I'm leaving. She goes to her keys, goes to get her purse to leave, and he grabbed her hand, he squeezed, he twisted, he held onto it, and she said, you're gonna break my thumb. And he said, I don't care. Because he wanted to intimidate her, he wanted her to be scared of him, he wanted her to capitulate. And then she says, okay, fine. You don't want me to leave, you can leave. Starts packing his things into a box, at which point he comes from behind, grabs her hair, yanks her back, grabs around her arms. And then finally, eventually lets go when she's calling the police. He knows that she's calling the police. He knows that. He said that she's on speakerphone with the police. So let's focus on that. She called the police. She locked herself into her version immediately. So any fabrication needed to happen on the spot. He goes out to his truck, and they both agree 10 or 15 minutes go by before the police. Right? Not a great response time. We'll get to how the police that. So that means he had 10 or 15 minutes. He knew he heard her thumb. He knew that. He had some time to think about it, to think, okay, the police are coming. Her thumb is hurt. How do I get out of this? And he says, well, she had my flashlight. I was trying to get my flashlight. You know, the flashlight story, he's stuck to it. Now, he is arrested. I know there were questions seeming to imply, well, the police made arrest because they had to make an arrest. But ultimately, what they thought doesn't matter. We're here for your independent assessment of the evidence. He's taken to jail. She doesn't feel safe at home. She doesn't have the means to care for herself, doesn't have the means to care for her child, because as we've established, Mr. McCullough was the provider. He's the hand that feeds her. The only way that she can escape that situation to protect herself is by taking money from his account. She did do that. That's not disputed. She's willing to admit to the things that she did that aren't going to look good. And then she left with the kid, and she left without filing for divorce. She left after having filed for custody of this child, which she's not a lawyer. That's really not how that works. She left the state. That is the story that is supported by the evidence. That is the story of an assault perpetrated by Garrett McCullough against his wife, Nicole. Now let's look through the counter theory. The counter theory seems to be that Nicole Polka is somewhat of a criminal mastermind who decided on the spot this master plan to set up her husband to steal his money, steal his child. This plan of, I'm going to lie to the police and make up a story of him hurting me so that I can get everything I want with this room. That's the counter. Counter theory is that they're arguing. Eventually he engages and it reached a 9. At first she's mad, and I think he used the word rage. She's directing rage towards him. Notice that terminology, right? Just clock comments like that, clock. And he's being the bigger person while she's directing the rage. And then eventually he decides he wants to leave, can't find his debit card, only information she must have stolen it. He's trying to leave and he says, fine, I'm gonna cut my losses and leave. He obviously eventually got to his truck. Because he got into his truck. And then she's holding his flashlight. They're in the thralls of this argument, and she's like, I'm gonna go get his flashlight. And then he went and takes the flashlight back from her and goes out to his truck. And at this point, she's like, he just took the flashlight. I know what I'm gonna do. I'm gonna lie to the police and say that he grabbed my thumb and hurt my thumb. He goes out to his truck, and while he's in the truck, she takes off her own fingernails, right? Because he indicated that her finger wasn't tapped. So he goes out to the truck, she breaks off all her fingernails except for one. And here in Peoples 2, we'll break down the pictures more. It looks like it's not clear what's there on top of it. She indicated might have been a piece of a fake nail that broke. So for good measure, with that thumb, I'm gonna make it really convincing. I'm gonna snap the nail and leave that there and be like, look what he did to me, police. And the swelling is because her thumb was shot 6 years ago. That's explaining that. So that's what she's doing in the house while he's in there not thinking about what he's gonna say to police. He's trying to call people and say that he's going to jail, which, like, note that admission. Okay, he's in the truck knowing that she's gonna say something that's gonna get him put in jail, so he has to cook up a story that gets him out of it. Oh, I was just trying to take a flashlight. But he's not thinking about that when he's in the truck, right? He doesn't think about what he's gonna say to the police. And then her plan goes into motion when he goes to jail. Okay, this is my chance to steal his money and get out of Dodge, right? So even though, so that's the counter. And which one of those seems more realistic? Remember in jury selection, when I asked people who has experience with domestic violence versus who has experience with false police reports, right? Let's use our common sense here. Which theory seems more likely that this actually happened? And Mr. McCullough then needed to come up with a story to cover for himself. And there's lots of other messy, crazy stuff. The judge indicated that she has questions. I do too. All right, this could be the episode of one of those TV shows, right? Now let's go through the testimony of these witnesses. Let's start with Nicole. First thing I would note about Nicole is that she was honest about her lapses in memory, about how she doesn't remember everything right off the front. Now tell me this, if this is a fabrication, wouldn't she want to have a detailed story, locked and loaded, ready to go? She was honest about the fact that she couldn't remember everything. Okay. She was honest about her faults, right? She was honest about her yelling. She was honest about, when asked if she took money from his account, she owned that. Yes, she did. She was honest about things that didn't help her. And let's ask if that's the same for Garrett McCullough. We'll get to it. Another important thing about Nicole's credibility is that these injuries align with what she was saying. And we'll talk about this more, but her injuries align with what she was saying. All right. Now let's talk about her cross-examination. Cross-examination questions. We have here a very, very skilled attorney. He's been doing this for a long time. I will probably be asking him for advice after this. He did an excellent job cross-examining. But I want you to imagine, okay, if you are the person sitting there and you are being asked questions by this man who is representing the person who did this to her and exerting power and control, that can cause you to say things that sound like they don't line up, right? He could probably get me to confess to murder. That can cause you to get confused. Questions are moving quickly. They're coming at you in an accusatory manner. That can cause things to get twisted in your mind and make things look how they aren't. Okay. And moving past that, you saw her testify right here, right? That was a person who must have had acting lessons if she was making this all up, if she's fabricating, if this is just a fairy tale that she's telling. That is some incredible acting. Give her an award. Now, moving past her testimony, let's talk about these police officers. Two things can be true. The police can cut corners, the police can go through the motions, the police cannot do a great job, and also trying to defend me. I am not going to sit here and say, oh, the police did incredible work. Okay. But we still have evidence here that we can present to you that is sufficient to prove that the defendant is guilty. And I do want to touch on Nicole's testimony a little bit more because she's kind of an easy target, right? She's the one who was put on trial yesterday. And it's easy to go after her and try to make her seem like the bad guy, try to smear her, drag her through the mud. It's easy to do that. But I want you to focus on what matters here, what we're talking about, which is January 4th, and the evidence that supports what happened on January 4th. Now, getting into Mr. McCullough's testimony, it was clear that, stark contrast with that of Nicole, it was polished. He came to you, I think polished is the best word. He was prepared. He had every opportunity to make sure that he was saying what he needed to say to get out of it. Now, I'm not saying he did something wrong by talking to his attorney, by reviewing anything like that. That's not what I'm saying. I'm saying you can't acknowledge the reality of the fact that he had this opportunity to get ready, practice in the mirror, figure out what he needs to say to get out of this. He had that chance. That was rehearsed. Let's talk about some things that didn't necessarily line up. Where is you have defense A?
Not believe so. Should have printed it out.
I have it. I have the full right here. Now, initially, very clear, only room for one hand on this, right? And then we just kind of saw how that changed as it stopped serving, right? Only one hand on that. One thing I want to emphasize is he indicated that they were pulling on this for 5 seconds. It doesn't sound like a lot. Let's see how long 5 seconds is. That's how long, according to the defendant, who clearly is trying to defend his own interests, indicates that he was pulling on that thing. And initially, when asked, he is very open to the notion that his hand is on her hand, and then suddenly his hand is moving back. And I want to be clear, the evidence suggests that never actually was there a fight over this flashlight. But his story changed as it ceased to become self-serving, right? And what we didn't see was Nicole Polka's story change, right? We had attempts to sort of trip her up. I think a good example is the police officer just checking boxes that are actually asking, whether it's cross-examination questions, well, didn't you tell the police that you weren't afraid of him? And then the officer's like, oh, I never actually asked for that. I just checked the box. So there were issues like that. I think we have differing recollections of how she testified as far as who filed for divorce, but she was pretty adamant, in my recollection, that she's not the one who filed for divorce. And I do believe that we had some confessions from Ms. Nicole that in fact she did file for divorce. I don't want you to get caught up on that, okay? The purpose of that is about credibility. When you're talking about divorce, when you're talking about custody, you're talking about credibility. And those are ways in which she's more credible. Now, last thing I do want to go through is I want to go through these pictures. Because these pictures are important. These pictures are important. I'm gonna get them up on the computer because you can get some better resolution in this version. You of course have access to this. You've seen it in a bunch of different ways, all the same pictures. Let me pull up. Now we're gonna start with exhibit one. We're gonna zoom in a little bit. This one is useful, right? Because it shows the contrast between these two thumbs. Okay, these two thumbnails, those don't look the same, right? They don't. Now, another thing I'm going to draw your attention to, I think that is, look at the creases on her right thumb versus the creases on her left thumb. Okay, take a look at that. The creases on her left thumb are basically gone. Why? Because her thumb's swollen. That's swelling. I know we have this counter story about something that happened 6 years ago. No, that is a swollen finger that is clearing up these lines. Now look at these fingernails. These fingernails do not look the same. Something happened to that finger. Something happened. Now moving on to People's 2, which is more focused on just the thumbnail. Take a nice close look at that. The resolution is a little better. You had descriptions of a nail being torn back, and there's something on there. Once again, I say something happened because he testified that the nail was still on there, fake nail still on there when she left. So his version suggests that she did that to herself. She is so hell-bent on framing him that she must have done that to herself. Now, let's move on to let's do People's 3 next. You can see right here on People's 3, it's like a little balloon there on her thumb, on the joint. That's consistent with squeezing and or twisting of hurting a person's thumb, right? That right there, that is swelling. I don't think there's any dispute that swelling on her thumb. It came from somewhere. It didn't appear on its own. That is important, important, important. We have another angle of that same lump on People's 5, different angle, big lump on her thumb. That right there is swelling. That is consistent with what he described, what she described, and simply does not align with what he described. Now let's take a look at People's 4. And again, there's swelling further down the thumb. Swelling on this thumb. It didn't just show up out of nowhere. Something did that. Something happened that day that caused that to happen. Now, wrapping up, what I would say is a reasonable doubt in this case is about whether or not Nicole fabricated. That's what this comes down to. Did she make a false police report? Did she lie her front off to the police? Did she make this up? A not guilty verdict means that you have decided that is a realistic possibility. It is a realistic possibility based on this evidence that she sat there and lied to your face, that she called the police, made a false report on 911. Police came, she told a lie about what happened. Lies, 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 lies. That is what a not guilty verdict is. That it is realistic to believe that she just sat there and had been lying to you. That in this case is not a reasonable doubt. That's not a realistic scenario. The evidence here is clear, and the evidence here is that Mr. McCullough is guilty.
Thank you. Good afternoon, I guess, right now. I also want to thank you for your time and attention. I know it's take time out of your busy lives and schedules to perform this very solemn civic duty is an ordeal. And you don't get paid very much for it. So I do thank you. And I know I was watching you throughout the trial. You were all very attentive, and that's not always the case. So I do want to thank you on behalf of Mr. McCullough. This is my only opportunity to speak with you. The prosecutor has the burden of proof. So he is going to be allowed to get up and rebut any of the points that I make that I think are important for you to consider when you go back and deliberate. All right. The crime of actual domestic violence is a terrible crime. This was not domestic violence. The elements of domestic violence, as Her Honor read to you, one of them we're not disputing. Well, there's also the added element of occurring on January 4th within Ingham County, state of Michigan. Obviously we're not disputing that. We're also not disputing the domestic relationship element of domestic violence. There's categories, and Mr. McCullough and his wife satisfy 3 of those categories. They're married, they have a child in common, and they live together. So there is no reasonable doubt as to that element of defense. I would submit to you, you don't have to go back and deliberate on whether or not the prosecutor proved that domestic relationship. Prosecutor constantly said during his closing, something happened. Something happened. I think that's a concession. Something did happen. There was physical contact. And the version of events that my client told the police, he didn't have to say that he touched her in any way. He admitted that he could very well, and he never disputed the fact that he might have caused an injury when he pulled the flashlight from her unwilling grasp. It takes 2 to struggle over an object. This was not against Nicole Polka's will. He was trying to get his property back so that he could leave in an argument that both of them attributed as a 9 out of 10 in terms of a heated argument. He wanted to get out of there. She knew that he wanted his flashlight and needed it for work the next day. And she's taunting him by holding it. In hindsight, could he have maybe decided, you know what, I'll use another flashlight or I'll go buy one or something? Yeah, but what he did to retrieve his own property from somebody that is willingly holding on to it and not willing to let it go without a struggle, that is not an unconsented contact. That is not against Nicole Polka's will. He knows that because he didn't argue that that was an assault and battery. If it was, the prosecutor would have given you an alternate theory. Ladies and gentlemen, even if you believe Mr. McCullough's statement, that's still an assault and battery. He didn't argue that because that was not. What happened here was not an assault and battery. I'm going to go through the elements of that in a moment. Prosecutor mentioned power and control. What this case does show is that his arrest gave her considerable power and control. In the day or the days after this allegation, he's arrested, he's in jail, and just a spontaneous series of events. She files for child custody / divorce. She has a U-Haul arranged. She completely unpacks all of her property into a U-Haul, drives completely across the country to Connecticut. All of that happened while he was in jail or shortly after his release, where he has a no contact order forbidding him from going to the house. This 911 call gave her considerable power and control over the situation. Most importantly, their 1.5-year-old son, who unfortunately in a divorce, there isn't any winner. Okay. A lot of power and control over their son fell into her hands because of this 911 call. So let's talk about, I am very pro-police. Okay. I was a prosecutor for over 20 years. This police work is embarrassing. The prosecutor said, oh, yeah. The police cut corners here. They didn't do a thorough investigation. Yeah, when on that box that said any previous domestic violence incidents, no. Any fear that you have toward Mr. McCullough, no. He just randomly checked those boxes. What kind of police work is that? The officer, Officer McLean, that interviewed my client said, based on his statement alone, which was and let me submit this to you. The officer's account of my client's statement on January 4th was very consistent with what he testified to in court, because otherwise the prosecutor would have been doing a tap dance all over my client on all of the inconsistencies. I appreciate the compliment that the prosecutor gave me. I'll say this about cross-examination. It is not easy to cross-examine somebody that's telling the truth. It is very easy to cross-examine somebody effectively when their stories are inconsistent and when they're flat out lying. All right, Nicole was very easy to cross-examine. Prosecutor mentioned, well, my client had the opportunity to prepare for this trial, 2 months after the incident itself, which is fairly quick to get from an incident to a trial. Of course, Eric is going to prepare for this. This is a serious, the police didn't think so, and I'm going to get to that a lot. This is a serious charge. And he's facing a serious charge that he did not commit. Of course he's going to take it seriously. Nicole had the exact same opportunity. She had the exact same period of time to prepare for her trial, for her appearance in court. Is the prosecutor suggesting that she didn't take this seriously? This event was serious enough for her to file for custody, move out of the state with all of her belongings. To suggest that she didn't have the same desire and opportunity to prepare for the trial is ludicrous. She had every opportunity, and she has just as much motive to be ready for this ordeal as my client does. Of course, my client took this seriously. Prosecutor, I think 4 times said something happened. All right, well, you're the finders of fact. It doesn't even sound like he was really confident in what exactly happened. All right. There's 2 words for that. Reasonable doubt. If you guys go back and you're grappling with, well, was it over the flashlight? All of the prosecutor's questions of my client were regard to the flashlight. I don't know if he even mentioned a struggle over the keys. It's almost a concession that, yeah, this was over the flashlight. I don't think he actually asked my client about the struggle, any struggle over the keys. Something happened. If you guys are truly perplexed with what happened in terms of physical contact between the 2 of them, that's reasonable doubt. The other 2 words are that's not guilty. The instruction that the judge read to you is reasonable doubt is born out of the evidence or lack of evidence. Okay, that's the law that the judge gave you. That's the law that you are to follow. It's the law you took an oath to follow. Okay, let's talk about a lack of evidence. Prosecutor is going to have a chance to get up and rebut everything that I say. This is my only opportunity, so I'm going to try to cover all my bases. He might get up and say, well, yeah, what were the police going to find out if they did anything resembling a thorough investigation? Oh, I don't know. Maybe they would have talked. They did talk. Maybe they would have said, wait a second. She's saying it was over keys. And he's saying it was over a flashlight. Let's go. This was about 2:10 in the afternoon. Maybe their shift ended at 3. And they're like, we got a statement. Let's book them. This is the 50th domestic violence call I've had today. Let's go get some beers. Okay. You know who suffers besides society in that type of attitude, that type of shoddy, corner cutting police work? People like Mr. McCullough. He should not have been arrested that day. He wasn't going to be arrested until her version of events came out, that they did not even take a moment to explore the differences between their stories to see which one passed the smell test. Hey, Nicole, let me talk to you again for a second. Hey, he says this was over a flashlight. Where you know anything about this flashlight? That could have been important. She could have said, oh, this flashlight over here in the closet or on the counter, this one? And then the officers would have said, yeah, he said he took that out to the truck. Thank you. You think that would have been important in your deliberations on what happened or who's telling the truth? He says that the debit card, his debit card was missing. And that was one of the items of dispute. Was there a single question of Nicole about a debit card? Wouldn't that have been an important fact? Where the keys were. If he says that all the keys were taken and put into a diaper bag, but they're on the hook, they didn't look to see where the keys were. The main subject of her account and the main subject of his account could have been fleshed out in a matter of moments and documented. Would those things have helped you in your determination as the finders of fact about what happened, who was being credible? Of course they would. The nails. Nicole testified that she had no idea when or how all of her fingernails came off. That was her testimony yesterday. That's ridiculous. Okay, credibility contest. That's what we got here. You got two people that were present. On key points, there's differences in the testimony. So one of them lied to the police. One of them lied to you today, yesterday and today in court. Okay. The officers, if they would have seen 9 fake fingernails in a trash can or on the couch or on the floor, maybe taking a picture of them. Oh, she says that her nail was ripped off. Did the officer even once ask, can I see the nail? That's called evidence. This was such a ridiculously poor, it's not even an investigation. It was a nuisance call that they apparently, they didn't think to read their police reports before their testimony yesterday. They did nothing, and it was even almost a point of humor that the officer admitted that he did not do a thorough investigation. Somebody was arrested, somebody was deprived of their freedom and charged with a crime. You would think that they would take their job more seriously. They didn't. And I think if they did, we would not be here today. What I submit to you is that I'll also tell you that if a person says, I was assaulted and battered by X, police can act. That's probable cause. Police can act on that and make a lawful arrest. I'm not suggesting to you that this was an unlawful arrest. What I am suggesting to you is that at the very most, the evidence presented to you by this prosecutor was probable cause. At most. That's about, there's no numbers, that's about 50-50. It is undisputed that not a single bit of investigation went into this case beyond probable cause at the charging phase. We are not anywhere even remotely close to beyond a reasonable doubt that there's any version of events that you can go back and say 100% that's exactly what occurred. Let's make our verdict. All right. If you guys honestly are grappling with, was it over the flashlight? Was it over the keys? If you're honestly grappling with that, that's reasonable doubt. Because grabbing his own property back is not a crime. The contact, the incidental contact, while he intended to grab the flashlight, she refused to let go of it. He admitted to the police and to you that he yanked it out of her hand. All right. Let's look what the law is with regard to that. The touching must have been intended by the defendant. That is not accidental. And it must have been against Nicole Polka's will. It takes two people to struggle over an object. She could have just, well, not picked it up in the first place, but she could have let it go. And there wouldn't have been an injury. Definition of force and violence. As used in these instructions, the words force and violence, which are essential elements to what my client's been charged with, means any use of physical force used against another person so as to harm. So as to harm. He did not intend to harm Nicole Polka if in fact the injury that you're seeing was actually caused during that event. We heard about a previous injury, I mean, a bullet going through your finger, and medical procedures there. It's possible that it could be a little bit deformed, especially in light of the other one. My client never disputed the fact that, yeah, that might have happened during my retrieval of my flashlight. All right. That's incidental to his intent, which is to get his property back. That is not assault and battery. He was put 9 out of 10 in terms of anger and argument. 9 out of 10. If he wanted to assault and batter her, he was close enough, and he certainly had the ire to do it. All he did was physically, with regard to her, is to get his property back. He didn't punch her. He didn't slap her. He certainly didn't. So let's talk about the other allegations, the pulling of the hair and the bear hug. Okay. You have two witnesses that talked to the police and got up on the stand. Two witnesses that took an oath. One of them says that he pulled my hair. One of them says that he did not. One of them says that there was a bear hug. The other one says that there was not. All right, there is no corroborative evidence that those two actions occurred. No independent eyewitnesses, no video, no injuries to suggest that. All right, that's not there. That's 50-50 at best. The only substance that would be worthy of deliberation is a discussion about, was it over keys, as Ms. Polka indicated, or was it over the flashlight, as my client indicated? That's the only proven physical contact beyond a reasonable doubt. It was one of those two things. But if you don't know which one it is, that's reasonable doubt. Tie goes to the runner. in a credibility contest, consider the things that I would argue are very important in terms of your evaluation of Nicole's credibility. Note, I hope you remember the evolution of her testimony regarding the debit card. Because it began with debit card had nothing to do with this. I don't know what you're talking about. And I reminded her that she's under oath. And I think it dawned on her how easy it would be to prove that that debit card was used the next day. So then it was, oh, yeah, yep. He gave it to me 2 days ago. And yeah, I did use the debit card the next day, even though she was claiming complete ignorance of that fact. All right, that's huge. That was active deception that was called out in open court to you. All right. Why would she lie about that? Maybe because it lends a lot of credibility to his version of events. You know, like she did actually hide his debit card. That's why she lied about it. That's why she started off her testimony denying that fact, because it shows that my client was being honest back on January 4th. I think I covered all the points that I had intended to. Prosecutor's beginning remarks was this is all about power and control. You know, I would say that it is. You know, and should these individuals have ever been married? No. Should they ever brought a child together into the world? That's now going to be the subject of a bitter court battle, thankfully for another day. He's guilty of that. He's guilty of marrying poorly. You know, welcome to the life of junior enlisted people. It's one of two things usually. It's you buy a Mustang at 19% APR, or you make an impulsive decision to marry somebody that you shouldn't have. Right? My client's guilty of option 2 there. He's guilty of getting into an argument with his wife. He's guilty of using force to recover his property without intending any harm or injury. That's not an assault and battery. It's all about intent. He's not guilty of domestic violence. And the reason that you can be comfortable with that verdict is not. You might go back there and you might say, oh, you know what? He probably did that. He probably did it. Okay. The reason you can be comfortable with a not guilty verdict, even if you have that image in the back of your mind, is because the law does not allow that to be the standard. Ladies and gentlemen, I'm the prosecutor. Ladies and gentlemen of the jury, he probably committed domestic violence. Okay. That's what he's proven. He has not proven beyond a reasonable doubt that my client committed this crime. I would submit to you because he did not. But even if you believe that, yeah, it's likely, so it could be. Right? That's the standard to arrest. That's the standard to charge. It's uncontested that not a single bit of investigation went into this case after that charging decision, that low bar. Right? And here we are. He's got the burden of proving beyond a reasonable doubt. And perhaps that would have been overcome had the police done anything resembling a competent investigation. There's reasonable doubt born just out of their corner cutting, as the prosecutor put it. Corner cutting when my client is facing a very serious charge. That doesn't cut it. Not in this great country, that doesn't cut it. Hold the police to a higher standard when they're going to investigate and request charges of one of our fellow citizens. Hold them to a higher standard. This was not enough evidence to convict somebody in a court of law. Please find my client not guilty.
Something happened, something happened, something happened. Yes, something happened. I'll tell you the something that happened. This man right here with military training grabbed his defenseless wife by the hand and he squeezed, and she screamed out, "You're breaking my thumb," and he said, "I don't care." That's the something that happened. Now notice the lack of engagement with these pictures, the distractions about the police, the smoke screen. That's because these sync them. The something happened was about these injuries. Okay, the point I was making when I said something happened is that her thumb didn't injure herself. Now you want to talk about concessions. There was physical contact. He said that. Proven physical contact. Thank you for that concession that we proved physical contact. Now, I didn't want to go down the absurd rabbit hole of this flashlight that is apparently the subject of this, because it's ridiculous. I didn't want to legitimize it. They weren't fighting over a flashlight, but because it's being twisted, the way it's being twisted, let's go down that rabbit hole. Even his version is an assault and battery. I mean, he testified himself, there's no room for two hands on that flashlight. And then not until confronted with the fact that, oh, you said there's not room, then he's like, oh, it moved to the back. No, he sees her hand on there, he grabs it and he squeezes hard enough and long enough to do this. He knew there's only room for one hand on that flashlight. He made the choice to grab her hand. That right there is intentional offensive contact against her will. She could have let go. It was mutual. Could she have let go? If his hand is over her hand and he's squeezing, he's pulling, could she have let go? And again, my position is that that didn't happen. My position is that this man went to his truck and thought, how do I get out of this? I know. I say it was over a flashlight that she was keeping from me. Now let's talk about these pictures that were not discussed at all, because it seems as though they're almost, they seem to be conceding that he did this to her. That something happened, again, something happened to her thumb. That's the point I was making. This didn't just like materialize out of nowhere. And it seems as though they're conceding that. They seem to be conceding that Garrett McCullough happened to her thumb, that Garrett McCullough did this. This doesn't happen by accident. This level of broken nail, this level of swelling. Let's talk about some distractions, because when the facts aren't on your side, I appreciate the concession that we probably proved domestic violence. That was polite. We proved it beyond a reasonable doubt. Who is the one who wants to focus inside the house on January 4th? That was us. Who wants to say that was bad police work and just go on and on about the police and hold the police to a higher standard? It seems to be saying that if you find him guilty, that means you're endorsing bad police work. Well, counterpoint, we have a victim here who was assaulted by her husband. You're going to find him not guilty to stick it to the police when she actually was assaulted? Now let's talk about Nicole Polka, who has become a punching bag. Okay, yeah, he didn't punch her. She's the one who called the police. She's the one who had her hand grabbed and squeezed. And then she is getting bulldozed up here on the stand. She's getting bulldozed. And now she's getting disparaged. She's being called a liar. She's being accused of exerting power and control. I mean, it's a cliche at this point, right? It's a cliche. Woman reports abuse and then is put on trial. That's what happened though, right? That's not disputed. She reported abuse. And then this whole trial has been about her, about putting her through this fine-tooth comb, about putting her through the ringer. about dissecting everything that she said or did, faulting her for not calling the prosecutor who doesn't represent her and saying, may I please see the police report? That is what has been happening to her again and again and again. He's exerting power and control over her while she's sitting right there. Now let's talk about this debit card that now she's being accused of lying about. Let's try and remember the context of when she's talking about the debit card. She is fighting off accusations that she was hiding the debit card. So when she said the debit card had nothing to do with this, I don't know what you're talking about with the debit card, that was about hiding the debit card. And then when it became clear that they were talking about, do you generally know about this debit card? Is this something that you use? She admits, oh yeah, I did use a debit card, right? She could have denied it and said, I didn't take any money. Did you see any bank records? There was no proof that she withdrew money, and she admitted it because she's a credible witness. She's been taking a beating. She took a beating all day yesterday. This trial has become about shoving her face in the mud and dragging it. That's what this has become about. So who suffers when the police don't do a good job? The submission to you from the defense is that Mr. McCullough is suffering today. Well, don't crime victims also suffer when a woman calls the police and says, my husband just assaulted me. He just squeezed my thumb and hurt it. He pulled my hair. He bear hugged me. They suffer too. But I don't want to go down that rabbit hole. I don't want to get into the distractions. What I want is for you to focus on what happened that afternoon of January 4th. Now, last thing I want to say is I don't want you to fall into this classic defense work trap of the he said, she said. You can do anything you want as long as you deny it, right? Go into a back room, beat up your wife, come out and say, I didn't do it. Well, I guess you can't find him guilty. He says he didn't do it. Don't fall into that trap. We even have corroborating evidence. This is not just he said, she said, cancels out. Well, we can't say he did it because we weren't there, right? Don't fall into that trap. What I'm asking you to do today is we have a woman who courageously sat here and stood up to herself, stood up against the man who has abused her, stood up against the attorney who was attacking and berating her, and dealt with being dragged through the mud, dealt with being re-traumatized and re-subjected to this nightmare. I am asking you to believe her. I'm asking you to believe that she told you the truth.
Ladies and gentlemen, you've heard the closing arguments and you've heard my final instruction. I am going to lead you to the jury room. Remember that you must first select a four-person. And that four-person is to ensure that you carry your deliberations out in a business-like setting. Again, if you have any questions or you want to see any of the reference documents, the four-person will write a letter or note on one of the pads and they will give it to my court officer. One of you all was an alternate, so you're going to be released for the day in just a moment. Juror number 2. Thank you. Thank you for your service. If you want to go down to administration, let them know you were released as the alternate. And then I think you may have to go to Treasury before you leave, but they'll confirm, okay? You can have just a seat while we wait a moment for the court officer to return. You can bring the jury in.
Oh, okay. All right.
All right. You can be seated. Okay, my understanding is that you do have a verdict. Did you select the four-person? Okay, can you stand and read the verdict, please?
The verdict we have come to is not guilty.
Did you want the jury polled?
No, thank you. No, thank you, Your Honor.
Okay, thank you, and thank you so much for your service and for being attentive and diligent in your deliberations. Sometimes the attorneys might want you to stand back to answer some questions. That's completely and totally up to you if you want to do that. Otherwise, you're free to go, and I'll leave you in the hands of the court officer. Thank you again for reporting for duty. Maybe excuse. Okay, that's an acquittal by way of jury. I will get your paperwork in just a moment, okay, sir?
Thank you, Your Honor.